Nobody's on yet. There we go.
How do you like the logo in the background, by the way?
Looks great.
Nothing like shameless self-promotion.
All right, we've got some people joining us. We're gonna give it a few more minutes as people start to get logged on. So last chance to grab your water, grab your lunch, and we'll get started in just a couple minutes. All right, I think we're going to go ahead and get started. It's 3 after 12. So for those that join, they can just join in the middle and we'll start plugging away. So my name is Sarah Fluke. I'm the manager of membership and business development here at the AMA, and we're so excited that you took time out of your day to join us today. We have been putting on several webinars throughout the month of April addressing specific concerns related to the COVID pandemic for our members, but this is our first one that we've done specifically for our independent rental owner members, and we're excited to be able to provide you this content. So before I hand it over to Mark, just a few housekeeping. You are muted, so you will not be able to ask questions verbally, but if you have questions for Mark at any time, please put those questions in the Q&A function on Zoom. You'll be able to find that on your control panel, either at the top of your screen or the bottom of your screen. And feel free to ask questions at any time throughout the webinar. I will interrupt Mark. He's used to that. He's used to me interrupting him. So I will interrupt him and ask those questions on your behalf. And then secondly, just a reminder here that we do want to thank our patron members. We have a great group of associate members or vendors that we have in our association that do support us tirelessly, and we are thankful for their efforts. And if you are looking for services right now from a vendor, I would encourage you to reach out to the folks on this screen, or additionally, we have about 500 that are available through our vendor directory on our website. So we would encourage you to reach out to those folks first. They are here, ready, able and willing to help you during this time. So if you need anything, please don't hesitate to reach out. And then lastly, that's it. We've got Mark Zinman, who needs no introduction. He's a longtime member of our association, a great supporter, and a local attorney here in Arizona. and I'm going to go ahead and turn it over to him.
All right, let's see if we can jump here, and I'm going to take over the screen, share it with you guys to see if that works. That should get us there. All right, Sarah, thank you so much. Sarah, are you able to see everything?
Yep, you're good to go.
All right, you did yourself for a second, didn't you? Yeah, there's the mute, the parental side, knowing that there's kids somewhere in the background screaming. People always say when you're nervous, just imagine the audience naked. I assume most of you guys are sitting in your PJs at home, so that's not too hard for me to do. We're going to go through here today both the Federal CARES Act as well as Governor Ducey's executive order. I think, like Sarah said, please ask any questions as we go. I can't see them. Sarah will monitor them, though. I think it's critical because there's some dense legislation here that it really, your practical questions are the most critical things here. It's your issues as the independent rental owners are going to be different from the managers on site. You have a different perspective, different issues. A lot of the times, if it's your ownership, you're the one worrying about the mortgage, how it's going to be paid, your issues with the lender. That's obviously different than what a manager on site is dealing with in terms of worrying about vacancies, learning about the collections, but being one step removed from the owner and more reporting to the owner as opposed to being the owner. So I think it creates a different dynamic. Also, you have different tenants. A lot of the time, it's a different market depending on what properties you own. It's a single-family home or a small fourplex, as opposed to a 300-door apartment community. So we'll kind of go through everything. Like Sarah said, I'm an attorney here in town. I can answer any general questions as we go, and I really, truly do prefer that you guys ask questions, but we'll get started here. Purely almost every presentation I do, there's a tweet that applies to something. Seems like this one, I saw this yesterday, and it pretty much applied to everything we're seeing in terms of rents getting pushed away and how people are handling that. I don't know if anybody's ever seen thus far, is that across the nation, it's been reported right now that a third of renters did not pay their rent for April. That is a huge number as opposed to 82% for last year and 81% for March. It went down to about, I think, 68% for April of this year. The hope is, of course, with the stimulus checks coming out, that next month is better, but there's going to be more unemployment, so it really depends on timing for that. So we're going to go through. The purpose of today is really to address, under the CARES Act, under Governor Ducey's executive order, what your rights are as a landlord in terms of evicting your tenants. Because having a tenant in the property where you can't evict them is your bottom line. It hurts, it's crippling. I understand that. I'm walking countless clients through this very, very seriously. It's not easy. Up on the screen, what we've got here is a chronology of events I started putting together. If you think about how slow generally legislation takes to go, it takes years for things to change a lot of times in the landlord-tenant world, in law in general. Civil rights movement is a perfect example. I mean, we're talking years, decades, years, depending on how you look at it. So within a matter of 3 weeks, basically, the entire landscape of landlord-tenant matters changed here based on the orders we have. And we'll go through those legal issues. I have that note above that, though, where it's not just a legal answer, it's a PR issue. What everybody has to be aware of, we're going to talk today on what your legal rights are. Before you have your legal rights, though, you have to also be aware, running parallel to that is your considerations for public relations. There's an article this morning I saw in the paper as soon as I woke up about a mother that is being evicted. She has 5 children. She's being evicted because she's unable to pay the rent in the middle of COVID, and that one of her children had been shot in January. So she took off time from work to be with that child, and now she's being evicted as a result. That kind of PR is horrible. The reality is, under Governor Ducey's order, the landlord is entitled to file an eviction in that case, but if she can show that she's been affected by COVID, that case, then the writ would not issue. The article, of course, did not touch on that, did not touch on the fact that the landlord was proceeding under Governor Ducey's order. It just simply seemed to say that she was going to be evicted and implied that, you know, the landlord was horrible for doing this. So there's always the PR consideration that you should be aware of and take into account with what you're doing. So let's go through the dates real quick. They're not critical in terms of going forward. It's just kind of remarkable. So March 11th, that's where we got the state of emergency. City of Phoenix shut down after that. Then Governor Ducey came back, closed the bars, the theaters, and the gyms. And at that time, that's where my apartment communities also were closing those same amenities on property as well. Ironically, we actually saw a lot of tenants complaining, saying they wanted a reduction in their rent because the gym wasn't open. And I wrote countless letters to tenants saying, we don't make more money when the gym is closed. It's not something we want to do. We're compliant to an order. It is $1,000. Whether the gym is open is irrelevant to that. And we're providing a clean and habitable property, which is what the landlord is required to do. So for some of you as well that may own properties that are in the HOA, that's still the same position I take, which is if the HOA closes, the gym, the community areas, it doesn't affect the value of the residents that they're receiving. Your job as a landlord is provide a fit and habitable unit, and you're doing that. And so that's kind of critical there. March 23rd, this is where everything really started speeding up. Governor Ducey entered in an order defining what was essential services. And this was what's called a preemption. He didn't specify anything about those. He said, if you're essential service, which is real estate professionals, myself as an attorney, other maintenance, all those things were considered essential services. He said that the cities and towns can't restrict those people that are deemed essential services. That way the state as a whole is on the same page and you don't have municipality by municipality coming up with different rules. As an attorney, I'm always in favor of a preemption. Similarly, like why we have one Landlord Tenant Act in the state, that's also something that AMA has been trying to push towards as well, is to not have city by city Landlord Tenant Acts because it would create a headache. And stepping back from this, I will give a shameless plug at that point. If you're worried about legislative things that are changing in our state, I can't push you enough to get involved with the Multihousing Association. They are the face in terms of representing property owners throughout the state and legislation with landlord tenant matters to all sizes of property owners, whether you're a community owner or a single family home owner. The things that change year to year in the Landlord Tenant Act are done to protect landlords, are done by the AMA. All right, shameless pitch over. Let's jump into it. We got to keep going. On March 24th, Governor Ducey Executive Order 2020-14. Sorry. That is the one that everybody is considered as the moratorium on evictions, which we'll explain. 3 days later, the Federal CARES Act came out. The Federal CARES Act is where the stimulus package is. It's where the PPP for the payroll is as well. And then it had a control on evictions. Nobody really knew that that was coming. There wasn't a lot of notice about the landlord tenant side of what was in that bill. 880 page piece of legislation. And that you really had to dig into. I think about 500 pages in, we got into evictions. March 30th, we got the stay-at-home order from Governor Ducey, which is actually coming up at the end of next month. End of this month is supposed to be lifted. The expectation is Governor Ducey is going to amend it to somehow start easing things, or at least change it a little bit. And then also on April, just a little bit ago, he also actually put a moratorium on commercial evictions, which is interesting. All right, so we're actually going to go Federal CARES Act first and then go to Governor Ducey's. Even though the Federal CARES Act was implemented after, it was Friday on the 27th, what it does is it's for all properties across the country that in any way touch a federal governing program. So many people haven't thought about this since like the 4th grade civil rights, basic constitutional classes you may have taken. The federal government only affects things that affect interstate commerce, that go between states. That's when the government can step in, like welfare programs, things, big issues across the country, civil rights in certain cases. Generally, landlord-tenant is not a federal rights issue. And so we've never had a standard landlord-tenant act, which makes a ton of sense because, New York has very different landlord-tenant laws than we would here. So the feds can't just come in and say you can't do an eviction. What the feds had to do was make some sort of connection to federal law. And the way they did that, saying, if you are a property owner, whether you're a multifamily property owner or a single family property owner, doesn't matter. If you are a landlord and you have any program that basically touches federal law, federal insurance, federal mortgage, then you're going to be bound by the CARES Act. And what that does is it creates a 120-day moratorium period on filing evictions for non-payment of rent, notices to vacate, and it requires landlords to waive late fees. So now, what that requires and what we're telling our clients is they have to figure out, do they fall under one of those provisions? So here is a long list laundry list of who it may apply to. If you notice at the very, very bottom, there's the comment under C, properties with federally backed mortgage loans. That's your Fannie, that's your Freddie. But also if you participate in Section 8, that would be as a federal program as well. And the way they actually did it under the CARES Act is they just referenced all programs that are referenced under VAWA, which is the Violence Against Women Act. And under that federal law, it references all these other things, which is the public housing, Section 8 project-based, Section 8 vouchers. I mean, things, any program that the federal government touches is meant that you as a landlord are now governed by this CARES Act. So it's incredibly broad. Many people, if you don't know whether or not you're governed by the CARES Act or whether you have federal backing on your mortgage or insurance, you may have to actually reach out to your lender, because in those ones, they're saying you cannot file evictions, period. It is a 120-day moratorium on evictions that are non-payment of rent cases. If there's a non-compliance issue, if there's an immediate issue, that is different. It's a little less clear. It's more of a gray area if you have a non-renewal issue that, you know, if you serve renewal prior to the CARES Act being implemented, and then afterwards that notice came up. For example, if the notice had been served March 2nd and the tenant's supposed to move out April 31st, if there's 31 days, I'm not even sure off the top of my head, then you'd be able to file that. That is a gray area. You'd have to talk to your attorney about, we all have kind of our opinions on whether that's legal or not. What is clear though from the statute is that for 120 days from March 27th, you cannot file an eviction for a non-payment of rent case. That is a very hard problem for a landlord to deal with. That's 4 months of not being paid rent. And a lot of times it's going to be longer than that as well, because the law says you also can't serve the notice to vacate until 30 days after that 120 expires. So you're potentially looking at a 150-day moratorium for the filing. And it's just, I'm understanding and I'm sympathetic to how bad that is. The act also says that if you're one of those landlords that this applies to, you can seek a forbearance, meaning you can delay payments. Nothing's waived. You just simply don't owe the money when it's due. Interest still accrues, the money's due. The hard part about that is, and the frankly pathetic part about that, if you will, is that the moratorium that applies to you receiving on your loan, it applies from 30 days potentially to 60 to 90. It doesn't go past 90, whereas the moratorium on evictions is 120 days right off the bat, potentially up to 150 days. So I think that's just a miserable part of the law. I know on the national level, I know here the AMA is working with the National Association as well to try and get that cleaned up. There is expected to be a fourth legislation from the feds setting forth what the rights are. There's a lot of advocates right now pushing that it be done, that more legislation work to protect landlords, to give forbearance, to exchange it, and really to protect the landlords, because they were kind of caught in the middle here between trying to protect tenants and not doing enough. So there I said, if you have that federal backing, if you're federally insured or you participate in one of those programs, the CARES Act applies. And if it applies, you've got a 120-day moratorium on filing evictions for non-payment of rent, 120-day moratorium on late fees and charges relating to the non-payment, and also you can't serve a notice to vacate. Of course, in Arizona, we don't have such a document called a notice to vacate, right? We have 5-day notices for non-payment of rent. We have a 30-day non-renewal. I don't know what a notice to vacate. So it's really speculative. It's dealt with case-by-case basis. Generally, our understanding is that, you know, it's a demand for payment or for the tenant to get out, which would be a 5-day. So you can't even serve the 5-day in that case under the Federal CARES Act. We're really hoping there's legislation clarifying what that is. And that goes back to my point earlier about federal law versus state law. Since we don't have a federal landlord-tenant act, when the feds come out with these laws and use broad terms like notice to vacate, we as attorneys have no guidance because there's no definition and it's impossible to determine what is intended. I mean, the expectation is they wanted to stop all notices for non-payment, but under this it seems to imply a notice for non-renewal as well. So here's the advice for you. First, talk to your lender immediately. Figure out if there's a federal program. The only way to be sure is you don't have one is that you don't participate in any like Section 8 program and you have your house paid off, your rental paid off, in which case you're not governed by the CARES Act. You just default, then you have to worry about what Governor Ducey's executive order is. If you are governed by the CARES Act, I can't stress it enough. This is the time to be working with your residents. And let me step back. I think you should be working with your residents regardless of whether you're bound by the CARES Act. This is an unprecedented, miserable time in our country. It's bad for residents, it's bad for the landlords, it's bad for everybody across the board. As much as possible, you want to try and talk to your residents with them on payment plans. If you haven't done payment plans before, this is a good time to start. I personally take the position that there's no fair housing issues in terms of allowing payment plans now when you haven't previously done so, provided it's, you're doing it just for this short time period, and you can always stop later down the road or next year when this is no longer an issue. For fair housing purposes, if you are doing payment plans, I do suggest that you be consistent in what your policy is. As an attorney, any kind of inconsistency I see that managers are doing scares me. Fair housing is consistency over time, consistency, which means if you're going to do a partial payment plan, know what you're willing to offer to those residents, right? Let's say you want half up front and the balance at the remainder of the month. That's fine. Just put a policy saying that's what it is. Or maybe you're willing to accept payments weekly. I don't know. To me, it doesn't matter what the policy is. It's that you follow it time in and time out. So whichever resident contacts you, you give them that same information and then that same option. Along the lines, for those that are not serving non-payment rent notices because of the CARES Act, I generally suggest send out courtesy notices to your residents, similar to what your 5-day notice would be, but don't make the demand for payment. Don't threaten that you're going to file suit, but just really a record of accounting saying, look, we notified you, that was what was owed, plus your late fees. Well, you can't do the late fees in the interim of the 120 days, but basically you're accounting for what's owed, any other charges for water, utilities that may show up as well, and you're documenting that month after month. And so that finally, when the moratorium does lift and you're able to proceed, at that point you can say, okay, this is everything I've done, Your Honor. They just haven't paid. We want the eviction. It makes it much more clean to proceed than just having gone dark for 4 months with your resident. Okay. So again, that's the Federal CARES Act, the big bubble that covers everybody if you're in one of those federal programs. That, of course, leaves out everybody else that if you're not in the federal program. So you are better off having not participated in a federal program, no question, because then you can avoid the CARES Act entirely. Even if you avoid the CARES Act, though, you're governed by Governor Ducey's executive order, the 2020-14. Well, you're governed by all of them, but this is the one that affects evictions. So there was a ton of false reporting on this when this came out. News reporters all over in print and on TV said, oh, there's a 120-day moratorium on evictions. You can't do anything. That is truly a false narrative. I think that was a benefit to Ducey in terms of he gets that narrative. It looks like he's there helping people, and he is. But the actual executive order doesn't go that far. And just for ease of terms, I always refer to it as the EO as well, just so if you get confused when I start using it. But what the EO did is it created a temporary halt on evictions only at the point where the writ is about due, not at the notice, not at the filing, not even at the judge stage. A landlord, provided that they're just on EO and not under the CARES Act, can proceed entirely through the process that they always would for a non-payment of rent, period. That means you serve your notice when it's due. You file your eviction when it comes up, when the notice expires. You go to court, you get a judgment. COVID-related issues is not a defense to the non-payment of rent. Tenant still has to pay their rent. The judgment will be entered, and then 5 days later, the writ's available, and you can ask for the writ of restitution. What happens at that point? This is when the EO kicks in. The writ is issued, it's signed by the judge, it's given to the constable. The general process is the constables contact you and say, hey, I'm going out to the property to execute the writ. You meet the constable there. At that point, if the tenant alleges that they've been negatively impacted by COVID, the constable is given discretion not to execute the writ of restitution. So that's important. We'll get into the specifics of what's required there, but what happens is you can entirely go through the process. It may just get stopped at the writ of restitution stage. So a lot of clients say, well, why would I even go that process if it can get delayed? Well, first of all, not all tenants are going to claim COVID. Not all tenants are going to be there at that time, and you can just simply execute the writ and be done with. But two, and more important to me, I think it's critical that landlords proceed with that process, because a lot of times where tenants are on the fence, if you don't do anything, if you don't invoke your rights, they're not going to pay you. We see that time and time again, where basically every month of my practice, to be honest with you, the 15 years I've been doing this, you serve the notice, some tenants pay, then you file the case, more tenants pay, and up till time judgment, everybody else then tries to pay, and some people simply just can't. You're going through that process motivates the tenant to pay. A lot of tenants that are having a hardship or having problems financially right now or medically, that may not want that eviction against them, they may not be able to pay the rent, and they may need that extra time that the EO provides for them. But if you proceed with the court and get a judgment against them, that gives you additional leverage to work with them, to not work with them. It just simply documents your file and prepares you, and it puts you in a better position. If you can motivate your tenants to pay you, you use all your resources to do so. And that's why I suggest, if the tenant's going dark, go all the way through, do the judgment, get your eviction, and if it's stopped, it's stopped. But if you can use that to have the tenant contact you to do a payment plan at that time, that's the best benefit you can get, is to make sure your residents are working with you, and then to protect your property as well. So as I said, let's presume for a second, you do your 5-day, go to court, get your judgment, the writ's available, the constable then shows up. So that list right there is what a tenant can do to show to get a temporary delay. Now, this doesn't automatically mean they get a 120-day delay. For example, the person has been diagnosed with COVID, they must be quarantined, a member of the household has been, they suffered a significant financial loss, the resident has a condition which makes them more susceptible to COVID, or the resident's at home stuck watching their children, and that they've obviously been impacted in that way as well. So let's look at the first one, for example. A person's been diagnosed with COVID. If they've been diagnosed, theoretically, we're talking about a 14-day quarantine generally, time for them to either get healthier, depending on how long it works, or the time that they're actually potentially going to spread that to somebody else. I think what most recent medical reports are is they have to have no fever for 3 days before they can go back in public and the quarantine can end. So under that, if the constable goes out there, let's say you've gone through that whole process, constable goes out there, tenant says, hey, I'm quarantined, I can't leave. The constable is supposed to give them more time. But that doesn't mean it's 120 days all the way to July 23rd. Potentially that could be another week, could be 2 weeks, or maybe even a couple of days. So if you're not going to file your evictions because your tenant's quarantined, you're literally losing a lot of your rights that you have and a lot of money that you could otherwise collect or do something else with your property. For me, at least, I think the biggest concern of where somebody could stretch out that 120 days is the resident a condition which makes them more susceptible to receiving COVID. If somebody's immunosuppressed and the constable goes to execute, they tell them that they're immunosuppressed, the constable is going to give them time. Well, what that time period is going to be is not really clear, because they could get better in a couple of days, but not with an immunosuppressed type of issue, right? I mean, it's going to exist for a long time. And so they're the ones that I would see are going to be the ones seeking the 120 days. The earlier ones, such as the residents suffered a significant financial loss due to COVID, I think with all the stimulus coming out, which is $1,200 a person, and I think that's up to they make $75,000 or less a year, they get that full $1,200. So that could be $1,200 or $2,400 for a couple, plus $5 child, plus unemployment has kicked in with an additional $600 up to by the Fed. So that's a significant influx of cash that people can be coming into. And so whereas maybe on April 1st, somebody was financially affected significantly by COVID, by the end of April, they may be a lot more liquid and be able to pay the rent. And if they're not at that point, then you have a right to potentially have them removed. What's important to note, I understand entirely, those 5 bullet points right are as broad as they get. And everybody in this country, myself included, I have been infected by COVID, no different than everybody that's watching this video as well. I understand it. The feds wrote it. Governor Ducey wrote it this way intentionally. I think the underlying health concern is you don't want somebody on the streets that's been diagnosed with COVID. You don't want somebody kicked out of their property. It makes sense. People that just have short-term financial impact, give them some time so they can get their stimulus. But it's just a broad statute, a broad executive order. And again, that delay on the writ only applies, there's an exception for it, I should say, for immediate and non-compliances. So if there's guns on property, drugs, constant problems, partying, too many occupants, too many pets, you can proceed with the eviction on that. You do your notice, file your case, go to court, and then the writ actually will issue. There's no delay there from the constable. All right. So again, let's go back to the practical steps. We're assuming here that you're not governed by the CARES Act under the federal law, and you're really just governed by Governor Ducey's executive order. That means our suggestion is serve your notices. That is the first notice to your tenant saying, hey, I can proceed with my rights if I want to. Please contact me or pay your rent. It's the motivation again. If you go dark on your tenants, my guess, your tenants are going to go dark on you. Like I said, we know what April's numbers have come in at. I think I said it's been a third across the country. Arizona's delinquency is not that bad, just what I'm hearing anecdotally from clients, but nobody knows what's going to happen in May. So serve your rent notices as soon as they become due. File your eviction, pursue the judgment, go all the way through court. We're doing court right now telephonically. If you're an IRO member and you happen to be doing your evictions yourself as well, courts are allowing you to call in. There's actually what's called a virtual courtroom. You call in with probably 30 other people on the line and you do your whole eviction case telephonically. It gets a little complicated for trials, for immediates, non-compliances, but it's an excellent way. I mean, I frankly was not comfortable going to court when all of this was going on with the spread of COVID. And it took a little while for the courts to get on board with the virtual courtroom, but they pretty much all are there within Maricopa County. Outside of Maricopa County, it is still a problem that we're working through. I, for example, have an attorney that just went down to Pima today just for an immediate. Once you've gotten your judgment, request the writ of restitution. If your tenant has already come to you and provided you documentation, you don't have to request the writ. I think it's a good idea to request the writ so it's in the queue. What Governor Ducey's executive order didn't really clarify is once that 120 days is lifted, is there just going to be this backlog of evictions in terms of just the writs that need to be executed on old judgments? And so we do suggest file the writ, even if it's not issued, it'll then be put in a queue, our hope is, so that when this is finally done with, the constables are just going to go back and start executing those writs. Now, under Arizona law, once you have a judgment, you're actually only supposed to get a writ for up to 45 days. Otherwise, you have to file a motion asking the court to issue it. We're hoping as well, we don't know how that's going to be addressed. We're hoping that is automatically extended and that those writs that should be issued now will be issued at the end of July when this quote moratorium is lifted, or the delay, I should say. Now, if you file the writ, constable comes out, knocks on the door, talks to the tenant, says, hey, I've been impacted by COVID. I shouldn't have to leave. I know that the governor stayed this action, but the tenant provides you no documentation. What's happening in these cases is the constables of all, at least in Maricopa, agreed, you know what, we're going to give the tenant 5 days to provide this documentation to the landlord. So that does require written documentation. It could be via text, email, however other method they have to get it to you, showing that they've been negatively impacted under one of those 5 enumerated reasons. Now, if for some reason you think it's fake, you think it's all a lie, or you just don't think that they qualify for one of those delay, then you as a landlord, if you want to do it yourself or through your attorney, you have a right to file a motion to compel the writ. And that takes it from initially the constables making that determination. Now you're saying, you know what, Your Honor, I think the constable's ruling is wrong. I want you as the judge to look at this. So you file a motion to compel. The judge is required within 5 days to get a hearing on that. So they have a hearing. We've had numerous ones. I personally did 2 yesterday, telephonic, trying to explain to a judge why somebody doesn't qualify. I can give you an example. In one of them, it was actually an issue that the person lost their job before COVID took place, and that the judgment was for March before any of these orders took place, were enacted either. And so our position was that this has nothing to do with COVID. This is a pre-existing issue, and that they should be removed in that case. Thankfully, we were successful with that one. It really just depends on the judge that day, how they feel about it. So at least you have that right to file the motion to compel. Non-renewals, these are the kind of things to think about as well, how you guys want to be handling these. What do you do with non-renewals? The way the law, Governor Ducey signed that executive order, it said you're not allowed to do evictions. It made a simple exception, though, for evictions under 33-1368A. Now, I don't assume you guys to be boring attorneys to know what 1368A is, but that deals with immediates and non-compliances. It does not include non-renewals, which are under a separate statute. So technically under Governor Ducey's order, all evictions may be halted at the writ stage if they are not a non-compliance or an immediate. So again, if you're thinking non-renewals, let's say you served a non-renewal now for the end of May. come June 1st, you can file the eviction for a holdover. But the tenant may get the right to, quote unquote, temporarily delay the issuance of the writ, depending on what's going on in their life and whether they qualify under those 5 standards. Resident requests. This is not a CARES issue. This is not a EO issue. This is just simply the practical side of, hey, we're in an international pandemic. Do you guys really want to go in and fix repairs in a unit? Big disclaimer here, of course, anytime you get a request from a tenant, your job is to go in and fix it. And so anytime you're not fully doing that, I would strongly suggest you talk to your attorney to properly document what you're going to do. Generally, my approach to that, though, is minor repairs do not need to be corrected at this time. You only need to maintain essential services. If there's a leak in the unit, you better go in and fix it. If the air conditioning is not working in the next couple of days and we hit 90, 100 degrees, you need to go in and fix it. You should send in vendors. You should have protective gear, the PPE, have them wear it. You really want to work with the residents. If they're acting in good faith, it shouldn't be a problem, right? You contact them, they can leave the residence if they want, or they could be there having masks and having hand gloves if that makes them more comfortable, and your vendors should be doing the same thing as well. The only thing you can't do is just simply blow them off and say, no, I'm not doing that. We've got COVID-19 and it is an issue. I'm afraid to go in your unit. Unfortunately, your job is to go into that unit for those essential services that are needed.
Mark, we have a question.
Please.
So if a multifamily property owner has no mortgage, it is owned free and clear. Just wanted to clarify and make sure that the owner is not subject to the CARES Act.
Absolutely. If they're free and clear, they're not governed by the CARES Act, provided they don't participate in any federal programs. So if it's not a Section 8 property, it's not a LIHTC, which is a low-income housing tax credit, then they're not. I will give you full credit, Sarah. I don't even know if you just made up that question, but it perfectly teed it up for the next slideshow. This slide we created to really walk clients through where they're going, how they handle these different issues. Sarah, if people want afterwards, Sarah can email you a copy of this. See, I threw you under the bus there, Sarah. You do more work from home. But basically you start, and this is kind of the way we looked at it here today, is looking through the overview and then getting down to where you go. So the first question, of course, is, are you governed by the CARES Act, yes or no? If you're governed by the CARES Act, then you go to the left side of that, which is you can't serve a notice for non-payment, can't file an eviction, and can't charge late fees for that 120 days. That really is a federal moratorium for the non-payment issues. And what's an important note there, if you look in that second box on the left, it says it applies to all residents in these properties, not just those affected by COVID. So like we talked today regarding the governor's EO, they're only getting an extension on the writ if they've been affected by COVID, which again, general, broad, I understand that. The federal doesn't even care if they're affected by COVID. It's just simply, period. If you're in one of these properties, you have a 120-day moratorium. So the question was, if I'm in one of, if I have a multifamily property, it's paid off, you go through this, you don't qualify under that first top paragraph, you're not covered by the CARES Act. So you go then to the right where it says no, and then you follow this through. If you're not governed by the CARES Act, then you're still governed by the executive order. What type of case you have? You have that non-payment, non-renewal, you head to the left a little bit, and it says you can serve the notice, you can file the eviction, and you can even go through and get a judgment. The only thing the Governor Ducey's order does is either delays the execution of the writ for those people affected by COVID, or it allows the writ to go through. If they're delayed, that could be that temporary delay, meaning the person's quarantined, they'll be back on their feet in 2 weeks or something, or maybe they're lying and you can seek a motion to compel. The alternative is, again, go back up a bit, if you're back under Ducey's order, but you have a non-compliance, everything is the same. You file your notice, you serve your notice, you file your complaint, you get your judgment, and you do the writ. Nothing is stopped by that. So in terms of everything being entirely the same, the far right is that you're not governed by CARES, you are governed by Ducey, but you need immediate or non-compliance. So your eviction should proceed no different than pre-COVID-19. And so that's kind of your overview default of where do I go? What am I doing? This is so much legislation I don't even know what to do with. This chart kind of walks you through everything. Oops. Let's go. Next, shameless plug there. If you can see it, we have a YouTube channel we started a couple weeks ago. really kind of walks through a lot of COVID issues. We had one on the CARES Act, one on the EO as well. But we also have general views on fair housing, basic landlord-tenant serving and notices. So you feel free to go there, subscribe for that as well. I'm happy to answer any questions as well if you guys have any. It's obviously a lot of material. Like I mentioned before, the CARES Act is 880 pages. That's the PPP plus this moratorium on evictions from the Fed side. And then you've got Ducey's executive order, which is, I think, 4 pages. So a lot of stuff, different sizes, but I'm happy to answer any questions people may have.
So Mark, quick question on the work order or service order legality. If they hire a vendor to come in and perform services, and the vendor doesn't have proper PPE, who's liable for that, the landlord or the vendor?
Interesting question. So I think the general default, in my opinion, and of course it always comes down to legal arguments, if you hire a licensed contractor and they do something wrong, the contractor is responsible for that. You didn't negligently hire somebody, so you're fine. If you use an unlicensed contractor, though, you're negligent in hiring them, and if they do something wrong, then you're potentially still on the hook for that. But that did remind me of a good thing that a lot of IRO members may not know. Generally, everybody is aware that if a tenant serves you a notice, whether it's a 5-day or 10-day, you've that time to get in there and cure that issue. But a good thing that the AMA did a couple years ago in terms of changing the law was that if a tenant gives you a notice saying, hey, you've got to fix this issue, 5, 10-day, whatever it is, that notice constitutes permission from the tenant to the owner that the owner can go in and make those repairs. So the owner doesn't have to serve a 2-day, which means you get a notice from a tenant. I would suggest contacting people right now due to COVID, so you don't like surprise them at their door and they just shut you out. But you don't need any further notice to them. So you can contact them saying, hey, I'm going to be there tomorrow at 2 with my vendor. We're going to go in and fix this issue for you. I see too many people, though, they're scared to go in and they don't want to do anything. That's just not an answer. You have to respond. You have to address the tenant's issues. You don't personally have to go in, but somebody does need to go. And then as always, COVID, no COVID issue, regardless if this was a year ago, I always tell clients, follow up afterwards, say what you did and the fact that you believe you've corrected their issues and their repairs, so that to make sure that, you know, you kind of put a bow on it at the end.
A follow-up point to, you brought this up earlier in the presentation regarding that 4th phase of legislation that we all have our fingers crossed on that will hopefully provide more protection for landlords. The National Apartment Association is urging folks within the industry to reach out to their member of Congress and urge them to protect landlords. We did send that information out to membership last week. In an email blast, there's a template that you can fill out or you can edit. So I would encourage you, if you haven't done that yet, this is really the time for you to voice your concerns as an independent rental owner and make sure that we move forward as a united front. You can find the information through the NAA's website. You can also find it on our resource page on our website, or you can email me directly and I'm happy to send you that information.
And to piggyback on that, I mentioned it earlier in terms of really try and get involved with the AMA. It is critical what the AMA does down at the legislature. They are the sole voice, as I mentioned earlier, representing landlords in the entire state of Arizona. And I think, if nothing else, what should be taken from the CARES Act and from Governor Ducey's order is landlords don't realize how easy they've had it in terms of the past 20 years in managing rental properties in the state of Arizona. And people always take that impression, oh, well, things are always going to be this way. Things are never going to change. The AMA has been very active in pushing against such proposals as rent control. Rent control could significantly alter, it would be a cataclysmic shift in the way properties are managed here. And everybody I've always talked to says, oh, it's never going to happen. The reason it hasn't is because the AMA. But I can tell you, the fact that Governor Ducey put out this order, the fact that the federal government put out a 120-day moratorium is proof these things can happen. You have to be active. You can't just assume that because something's been there for one way, that it's just going to continue indefinitely. You really have to support the association that supports you guys down at the legislature.
Thanks, Mark. We appreciate that. There was another question, that beautiful flow chart that you created. We will make that available. So I will send it out to you after. Mark is doing another webinar for us at 2. So it'll be later this afternoon that we'll get that out to you. So watch for that. And I'll also send you a link to the recording. So if you want to go back through and watch this, again, you're more than welcome to. We're right at 12:45, but if I could take 2 more minutes of your time, I want to share a few things on our website with you, so you know what we have available for you. So let me just get here real quick. And when you log into your account, which you all did because you registered for this event, it'll take you to your member dashboard or your member compass here. And I want to highlight our legal forms section. So if you haven't accessed the legal forms section, I would encourage you to do so. We do have a lot of great resources here. Also, specifically, we've got a COVID-19 forms section, and there's a lot of great information here. Mark has been helpful with this. So there are specific promise to pay agreements, or if you want to waive late fees, service request questionnaires that you can ask your residents when they put in a service request. So I would encourage you to check this out. Additionally, if you have not visited our COVID-19 resource page, I would encourage you to do so. You can either access it on the homepage like I did, or over here on the right, there's the COVID-19 information page. This has, we've run this as a CNN style update. So all of the emails we've sent out, we keep updating here for you. So you can keep track of everything. And it, like everything else in all the other industries, it's been very fast moving, and changes are coming in at a pace that sometimes can be hard to keep up with. This is our COVID-19 resource page that has, again, just everything that you didn't want to know about COVID-19 is here for you. So there is a lot of great resources available for you to check out here. And we just want you to know that we're here to support you. We're here to help you. And if you need anything from us, you know, please don't hesitate to reach out. And I will just check one more. Looks like we don't have any more questions. So if Mark, is there anything else you want to add?
No, that was great. Thank you.
Okay. All right, guys. Thanks so much for joining us, and have a great day.